So one of our members was arrested at a protest. This was some time ago, maybe even a year, maybe 18 months ago. They kept him in custody over the night. He never said anything. I wrote out his case stated. The police had arrested him for harassment and alarm distress, Section 5, public order offence, and they had arrested him for telling them to fuck off, right, and calling them dickheads. Upon investigation of the statute, it turns out that Section 5 of the Public Order Act and under harassment, alarm and distress is what's known as a summons-only offence. It is not an arrestable offence. And they arrested him, handcuffed him, dragged him up, blah, blah, blah. Just to make sure you're aware, that the defence that was put forward was partly in relation to Justice Bean, who had already made it clear from the appeal courts and quashed the conviction of someone telling a police officer to fuck off, right? He quashed that person's conviction, and he stated, because the police didn't like it, that it isn't unlawful to tell a police officer to fuck off. It does not cause them harassment, alarm and distress, and the law was not put in place for that purpose. And he basically said it's not unlawful. It may be immoral to swear in public or to swear at all, but it is not illegal. Right? Again, they've got a monopoly where their own people trained to X standard. So if I talk about what happened with doctors and COVID-19, the doctors were trained by the pharmaceuticals to jab you up and charge you and say safe and effective, right? We all know that that's complete and utter bollocks, right? But doctors are trained by the pharmacies. The pharmacies have got control of the universities that train the doctors and train the doctors and nurses in the hospitals. The pharmacies conduct the training. You got the same situation with the law, right? You are far better off having a self-educated 30 years reading law, someone who has had an audience in the High Court, more than 10,000 hours experience of constitutional issues. And these people have all been misinstructed. So think about barristers, KCs, King's Counsel, judges, solicitors, being more or less a mirror of a Soviet society where the same thing happens with doctors, right? There's no difference. And people need to understand, and you need to be sharing this because it's important to understand that that particular judge, Judge Bean, was the very judge that quashed a conviction in the Court of Appeal and stated that he was sick and tired of these offences coming up. It is not a criminal offence, right? Well, secondly to that, it was me who highlighted it wasn't an arrestable offence. It was summons only, right? Now, if a police officer asks you for your name and address for a summons and you refuse to give it, right? Now, you can argue the legality of this at a later date. If you refuse to give your name and address, that becomes arrestable. But if you've done nothing wrong, that's when you sue the police, right? Because if that's a false arrest, right? And there's a number of torts that come into play, and for them torts, within a 28-day period of getting a response from the police solicitors on the tort going forward, you must make an application within 28 days for a jury, right? And you will get a jury.